might sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Stop shutting my mic off, please.
Your Honor,
Why are they shutting my mic off?
because he's talking.
I'm the federal witness of the United States federal government. I demand some respect, you. All I did was trespass on property.
Ma'am, you got to create the community that you want to live in. Okay. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, I need everyone to raise your right hand for me, please. Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes. Yes.
Thank you. Let's begin on the ladies' side with Miss Blackman. Miss Blackman, Blackmon, sorry. You're charged with one count of simple assault. This is a misdemeanor offense. Bond is going to be set at $3,000. You're charged also with one count of battery, which is bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Sonia Hewitt. Do you understand that, ma'am?
Yes.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working, yes or no?
Yes.
And you put down $0. It's $600 and then it's crossed out and then it says $0.
What's that for now?
Let me ask it this way. How much do you make per hour?
$12.75.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, ma'am, you're free to go back. Miss McDaniels? Miss McDaniels, ma'am, you're charged with one count of misdemeanor possession of marijuana. Bond is going to be set at $1,500, and you're charged with one count of driving a vehicle with no taillights. Bond is going to be set at $500. Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, Your Honor.
Okay, ma'am, you're free to go back. Miss, is it Nadume?
Hello, Your Honor.
Morning, ma'am. How do you pronounce your last name?
Madome.
Badume. Oh, I got it right. Ma'am, you're charged with one count of simple battery, family violence. This is a misdemeanor offense. Bond is going to be set at $4,000. There's going to be a stay away provision on this bond to stay away from a Brian Barnes. Do you understand that?
Yes, we live in the same home. Like we rent rooms in the house.
Okay. I will come back to that in a second, okay? Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Please.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, you said that, is it that the two of you rent a room?
It's like a boarding house.
Boarding house.
Oh, that's it. That's right.
Okay, sir, whoever just logged on iPhone, would you please turn your camera on? And iPhone 45, I need you to turn your camera on. I need you to identify yourselves. And I'll come back to you, ma'am. I'm sorry, I just got to take care of this. Okay, iPhone. Hello. Hadn't seen you in a long time.
How you doing, Judge?
I'm doing well. Who are you representing here today?
Vanessa Mendeley.
I'm actually speaking to her right now.
Okay.
So you have perfect timing. So ma'am, since you've hired an attorney, I'm going to start this over again, speaking to your attorney, okay? So I have set a bond at $4,000 for this offense. I've placed a stay away provision on the bond to stay away from a Brian Barnes, and that's where we were just having a discussion. So she said that they live in sort of a rooming house situation or rent a room. So this is what happens. Whenever, you can't imagine how many of these cases we get a week of battery, simple battery, criminal trespass, people getting in arguments, they're misdemeanor offenses, they're gonna bond out. What we don't want to happen is whatever dispute that led to her coming before me today to flare back up again tonight. So we place a stay away provision on the bond temporarily. They can petition for the solicitor's office to take a look at it. And if it's something they look and say, hey, we think this should be modified, they bring it back to us and we sign it. I've never known a judge to not sign it. But because I don't know her and I don't know him, I don't want to be in a situation where somebody's lying dead on the floor tonight because whatever action took place led to someone's death. But also, I tell people we just simply don't have the resources for law enforcement to be going to everybody's house to referee fights between adults. We got people who are getting guns stuck in their face. Their houses are getting broken into. We need law enforcement at those locations and not where a person can just walk away. So those are basic public policy principles behind that. Do you know if this is a situation where your client has another place to go?
Your Honor, it was my understanding that the incident location was in fact her place. However, I'm with her father now. So she can't be with her father. If the court wants, I need you to mute your phone because you're feedbacking.
Okay, so that's the other iPhone.
Yes, we both just logged on. We're outside the courthouse, Judge, and we got the.
So I am placing the stay away provision as it relates to Mr. Barnes, not to any location. So I can't kick Mr. Barnes out of that location if he's staying there because he's the alleged victim. If Mr. Barnes chooses to leave on his own, she can go back to that location. But the stay away provision is only as it relates to Mr. Barnes.
Understood.
And no contact, don't contact Mr. Barnes, any of that kind of stuff. Of course, as the lawyer, you can contact Mr. Barnes and you can do whatever you need to do to present your client.
Understood, Judge. And if ultimately Mr. Barnes is still going to be at that location, she'll be able to stay with her father and we can make arrangements that she'll comply with the stay away order in every way the court intends.
Okay, and if she needs to have items removed from the home, make arrangements as she's bonding out so that there's a law enforcement officer there, because we don't want her to get accused of doing anything and for him to get accused of doing anything. So we just do that just so that there's a neutral party and we don't have to deal with, they stepped on my toe as they were coming out of the house, that kind of deal.
Understood.
So she has a preliminary hearing date that's going to be set for November 8th, but it's going to get waived upon her bonding out, and she'll receive a new court date in the mail.
Judge, the only thing I would ask, if the bond amount is pursuant to schedule, I understand. Otherwise, because I know the family, mom and dad had recently divorced, they're in a transition period of getting sort of everything back on their feet. If the court would consider a slightly lower bond, it would just assist in terms of dad getting Miss Vanessa out of custody and start getting this situation behind them.
Sure, give me 1 second. So it looks like Miss Medley is on bond out of Fulton County right now for
Now,
aggravated assault.
now that I was not aware of. So that being the case, I would just thank the court for a $4,000 bond and leave that alone.
Yeah, so I'm gonna leave it the way that it is. And I always take a look. I will try to be fair.
Understood.
Yes. So is there anything else?
No, Judge, it's just good to see you again, and thank you so much.
Okay, it was great to see you. Tell your family I said hello.
I sure will, Judge. Take care.
Okay.
May we be.
Yes, sir. Have a good day.
Thank you.
You're free to go back, ma'am.
Thank you.
You're welcome. Next we have Miss Monolyn, Monlyn. Hi, ma'am. You're charged with 1 count of simple battery. I've set the bond at $4,000. There's going to be a stay away provision on this bond, a stay away from a Destiny Barrera, Barreira. Do you understand that, ma'am?
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir, I do not. You said my bond was 4,000, right?
Yes, ma'am.
Okay, thank you. Is that all you have?
Yes, ma'am. You're free to go back. Miss Powell.
Hi, Your Honor.
Good morning, ma'am. You're also charged with, actually it's battery, but I've set the bond at the same amount as Miss Monolyn at $4,000. There's also going to be a stay away provision on this bond, stay away from a Destiny Barrero. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. Courtroom 20, well, it'll be by Zoom, but it will get waived upon your bonding out and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am, you're free to go back. Miss Silva.
Morning, Judge Gardner.
Good morning, Miss Silva, ma'am. You're charged with 2 counts of interference with custody. These are misdemeanor offenses. I've set the bond at $1,500 for each count, so that's a total bond of $3,000. And I'll let you ask whatever question you want to ask in 1 second. Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Please, Judge Gardner.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, I cut you off. What was it that you wanted to bring to my attention?
I was going to ask the court if they would consider a lower bond. I am trying to get back on my feet. I'm currently going to be starting Capella for my EDD and curriculum and instruction. So I have an ongoing court case with DFACS that this is going to affect. And I'm not a flight risk because I very much think that my children are would be in better suited custody with myself, and I'm working towards the proper channels to do that correctly.
Okay, Ms. Silva, what I'll do is this. Given the nature of these allegations, I'm going to set a $500 bond for each count. That'll be a $1,000 total bond.
Thank you, sir.
Ma'am?
Yes, sir.
Please comply with DFACS and
Yes, sir.
comply with this stuff. I mean, this is it can be a short-term thing if you just attack it head on, deal with it, and then move on with your life.
Yes,
You're
sir.
children are gonna need you.
Yes, sir.
Okay,
Thank you.
ma'am? Do you have
Thank you,
any, you're welcome. Do you have any questions for me?
I hope you have a good day. Thank you, Judge Gardner.
Thank you, ma'am. Okay, we're gonna save Miss Yusufu for last. Miss Zephyr. Give me 1 second, ma'am. Miss Zephyr, you're charged with 1 count of criminal trespass. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from a Ronnie Bradford. He's also going to have a stay away provision on his bond to stay away from you. Do you understand that, ma'am?
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail for me to see if you qualify for the appointment of a lawyer. I'm sorry, ma'am.
You were cutting off. I didn't.
Oh, I'm sorry. Would you like for me to see if you
Yes.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No questions.
Okay, ma'am, you're free to go back. Now, let's bring up Miss, is it Yusufu? And we're gonna bring up,
Hello, Your Honor.
hi, we're gonna bring up, hold on 1 second. Okay, I'm sorry about that. On the male side, we need to bring up Mr. Anderson, Mr. Foster, and Mr. Nieves. And I just need, I'm gonna address each of you individually, but you're all in the same position. So I'm gonna make the speech 1 time rather than doing it 4 times. Okay. And ma'am, how do you pronounce your last name?
Yusufu?
Yusufu. Okay. So Miss Yusufu, Mr. Anderson, Mr. Foster, and Mr. Nieves, you are all in sort of the same position. The same rights and privileges, as I explained earlier, they apply to the 4 of you. You're in sort of a different category in the sense that you're being labeled a fugitive from justice. And what that simply means is that there's a warrant for your arrest out of another state. Now, you have additional things to consider with respect to that. You have the right to challenge the warrant, or if you believe that you are the person named in the warrant and that the warrant does show a charge, you can waive that hearing and then require the other jurisdiction, which is, we call it the requesting jurisdiction, to come and pick you up and do what they call extradition, take you back to that other location. The first thing I want the 4 of you to understand is that it is in each of your interests to hire a lawyer to represent you in whatever jurisdiction. And when I go to each person individually, I'll explain the allegation that's being levied against you. But if you were to waive the hearing today, then the requesting jurisdiction has a minimum of 30 days, a maximum of 60 days to come and get you. If they do not come and get you within that time period, you will get released out the front door. But it doesn't mean that the warrant goes away. So if you're released out the front door, you can encounter another law enforcement officer 5 minutes after you're released, and they run your information and see that there's a valid warrant for your arrest, and the situation starts all over again. Generally, the time period goes a lot faster, but the statutory time period is 30 days, and then the requesting jurisdiction can ask for an additional 30 days. If you decide that you want to fight this, sometime between now and the next 90 days, there will be a hearing to determine whether you are the person named in the warrant and whether the warrant does in fact show that there is a valid existing charge. At the end of that hearing, if the judge makes that determination, then the judge will sign off on the extradition warrant, and then that 30 to 60 day period will begin to run at that point. Is everyone with me so far?
Yeah.
Does anyone have any questions so far?
No.
Okay.
I
Miss-
do.
Yes, ma'am.
I just wanted to know, you mentioned earlier that the time frame typically goes a bit faster than the 30 to 60 days.
It can, ma'am, but I can't promise you. All I can tell you is that they have 30 days at a minimum, and it could be up to 60 days. I've had situations where the detective is waiting at the jail for the hearing to be over, and they take the person. So the fugitive squad is in contact with these jurisdictions, so they'll know what time period, what's going on. They'll know all of that stuff. Nobody is speaking to me about that. Does that answer your question?
Yes, sir, it does.
Okay, so Miss Yusufu, you are here. It says that there is a warrant for your arrest out of Collin County Sheriff's Office for fraud. And I do have the warrant number if you want the warrant number.
May I grab a pen, please?
Yes, ma'am.
Thank you, Justin. Yes, I'm ready to take that now.
Okay, it is 416-82811-2020.
Thank you, Judge.
And they said that it will extradite you. And I'm trying to see. Do you have any idea of what you want to do, whether you want to have the hearing or waive the hearing?
I believe I want to waive the hearing.
Okay, so you should have some waiver forms there, and you can sign off on that, and they will send them to me, and I will sign off on it, and the time will begin to run today. But I would encourage you to try to, as quickly as possible, to get a lawyer, because especially during this pandemic, I've seen a lot of jurisdictions where they will just go ahead and they'll just go ahead and grant a bond. So I can't give you a bond, but if a bond is granted for this, they'll send us the information and we'll release you out of the front door. Okay,
Yes,
all
sir.
right. So that should conclude the ladies' side. And when Miss Yusufu signs off on it, she can go back. Now, are you Mr. Anderson? Mr. Anderson, come forward, please. Mr. Anderson, sir, do you have any questions so far?
No, sir.
Okay, so it says here that you are wanted out of looks like it says St. Clair County Sheriff's Office for recovery of stolen property. And it says that they placed a hold on you to be picked up. I have your warrant number also. Do you want that?
No,
I'm sorry, sir.
I do not want the warrant number.
Okay. Do you know whether you want to have the hearing or waive the hearing?
I want to waive it.
Okay. Once you sign off on that, sir, you'll be free to go back. And again, please, as if you can, get an attorney to represent you up there, and it may make things go a lot smoother. Mr. Foster. Mr. Foster, sir, do you have any questions?
No, sir.
Let me read to you what the allegation is. It says that there's a warrant for your arrest out of, oh my God, it's hard to read this handwriting. It looks like it's Morrilton Police Department.
Morrilton.
Morrilton. Okay. It's an allegation of possession of dangerous drugs. So you want your warrant number. Okay. Do you know what you want to do, sir?
I want to waive it.
Okay. Okay. Once you sign the waiver, sir, they'll send it over to me and you'll be free to go back.
All right.
Okay. Mr. Nieves.
How you doing? Good morning, sir.
Good morning. Do you have any questions for me, Mr. Nieves?
I do, sir.
Okay. The allegation in your case is that there is that you're wanted out of Springfield, Massachusetts.
Correct.
Do you know whether you want to waive or have a hearing?
No, I want to waive it, sir.
Okay. And again, hire a lawyer up there as quickly as possible. And when you sign off the waiver, you'll be free to go back.
Perfect.
Okay. Thank you, sir.
You're welcome, sir. Have a good day.
You too. I can take a pause while they sign off on those if you need me to. Okay. Just let me know when we're ready to get back going.
Yes, sir.
Your Honor, they have signed and they have their copies, their one copy.
Okay. All right. Well, let's get back up on the horse. Let's start with Mr. Marcus Alexander Henderson. Mr. Henderson, sir, you're charged with one count of violating Georgia's Controlled Substance Act. I have denied bond on that offense. You're charged with one count of distracted driving. I've set bond at $500. One count of violation of Georgia seatbelt law. I've set bond at $500, and one count of driving a vehicle with no insurance, and bond is going to be set at $1,000. Because of this felony offense, you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. You're going to also have a bond hearing date set for November 11th at 8:30 in the morning. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, Mr. Alexander Henderson. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
Yeah, why was the bond denied for the marijuana charge?
Let's see. I'm going back. I think it's because you were on bond. Hold on. Yeah, you're on bond out of South Fulton from a October 19th arrest for battery family violence. That's
Yes,
why I was denied.
All right.
Okay, sir, you're free to go back.
Thank you.
You're welcome. Mr. Anthony. Good morning, Mr. Anthony. Sir, you're charged with 1 count of driving under the influence of alcohol. Bond is going to be set at $5,000. That's a misdemeanor offense. You're charged with 1 count of knowingly driving a vehicle with an invalid or canceled registration. Bond is going to be set at $1,000. You're charged with 1 count of driving a vehicle with your license not on your person. Bond is going to be set at $500. And 1 count of driving a vehicle with no tag. Bond is going to be set at $500. These are all misdemeanor offenses. So you're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you plan on hiring your own lawyer or representing yourself?
Hire your own lawyer.
Okay. Do you have any questions for me, sir?
What my total for my bond?
Your total bond is going to be $7,000.
All right, thank you.
You're welcome. Mr. Bradford. Mr. Bradford, sir, you're charged with 1 count of battery. This is a misdemeanor offense. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Jessica Zephyr. Do you understand that?
Yes, sir.
And she also has a stay away provision to stay away from you.
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Bradford. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
Yes, sir. Could you lower my bond a little bit because I'm on fixed income? I get SSI and it's not much. You do that for me, sir. I really appreciate it.
So, Mr. Bradford, let me ask you this question. Well, no, I'm not going to ask you that question. The allegation involving you and Miss Zephyr is basically y'all could have been like 13 years old. So again, these bonds are not meant to be punitive, but at the same time, can you imagine the resources that you and Miss Zephyr have used up because y'all couldn't act like adults? Can you imagine the person in this county that needed a police officer there because somebody had a gun pointed in their face and they didn't have a law enforcement officer there because you and Miss Zephyr could not act like adults? So, sir, what am I to do? Give me a suggestion.
I accept, Your Honor.
I'm sorry.
I accept. The,
Okay.
thank you.
Okay. All right, sir. You're free to go back.
Thank you.
Mr. Buckley.
Yes, sir.
Mr. Buckley, sir, you're charged with 1 count of robbery by sudden snatching. So, again, this is a situation of adults acting like children. But robbery by sudden snatching is a felony offense. I'm going to set your bond at $7,500.
Yes, sir.
There's going to be a stay away provision on the bond, a stay away from a Talaula Ma'alolo.
Ula Malolo.
What you said, sir, because I cannot pronounce that. You're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. You do understand the stay away provision, correct?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer? Or you're going to hire your own?
I have one, sir.
Okay. Do you have any questions for me?
My bond was 7,000.
500.
7,500.
Yes, sir.
Yes, sir.
Okay, you're free to go back.
Yeah.
Mr. Davis. Mr. Davis, sir, you're charged with 1 count of simple battery. This is a misdemeanor offense. Bond is going to be set at $4,000. You're also charged with 1 count of criminal trespass, which is also a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond, to stay away from a Fatima Murphy. Do you understand that, sir? Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? About how much do you make per hour?
$15.
Okay. You do qualify, sir. I'm going to, and I'm sorry, would you say that amount again? I'm sorry, I didn't hear anything.
$15 an hour.
Okay, thank you, sir. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Delgado. Mr. Delgado, sir, you're charged with 1 count of simple battery. This is a misdemeanor offense. Bond is going to be set at $4,000. You're also charged with 1 count of cruelty to children in the 3rd degree. Bond is going to be set at $3,000, and 1 count of obstructing an officer. Bond is going to be set at $2,000. These are all misdemeanor offenses. Hold on 1 second. Okay, Mr. Delgado, I missed this the first time. The simple battery charge is going to be dismissed. They did not name a victim. And that is a material element for simple battery. Doesn't mean they can't bring this charge back, but I have to follow the law just like everybody else.
I'm good.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Delgado. and I'm going to appoint a lawyer to represent you. Now, I'll tell you, the solicitor's office, they generally will accuse these cases, meaning they will formally charge the case by the time this November 8th date comes around. And they actually sit at their desk and they type up what's called an accusation. So this charge will probably come back, but for now, it's not going to be there as you bond out. Do you have any questions for me?
I'm gonna see you. What? So what's the total?
$5,000.
All right, that sounds good. Appreciate it.
Okay, sir, you're free to go back. Mr. Fuller. Good morning, Mr. Fuller. Sir, you're charged with driving under the influence of alcohol as a second offense. This is still a misdemeanor. The bond is going to be set at $7,500. You're charged with one count of improper lane change. Bond is going to set at $500. You're charged with one count of possession of a weapon during the commission of a crime. Bond is going to be set at $5,000. Charged with one count of violation of Georgia Controlled Substance Act. Bond is going to be set at $3,000. Charged with one count of possession of violation of Georgia Controlled Substance Act, possession of a Schedule I narcotic. Bond is going to be set at $3,000. And you're charged with one count of use or possession of a drug-related item. Bond is going to be set at $1,500. Because there are felony offenses that are contained in here, you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. The date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, Mr. Fuller. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
What's my total? Mine?
Mr. Fuller, you're making me do math on a Friday morning. Okay, hold on, sir.
Yes, sir.
By my public school math, it's $20,500. Okay, sir? All right, you're free to go back. Mr. Glover. Mr. Glover. Sir, you're charged with one count of obstructing or hindering law enforcement officer. That's a misdemeanor. Bond is going to be set at $2,000. You're charged with one count of pedestrian walking along the roadway. Bond is going to be set at $500. You're charged with one count of theft by receiving stolen property, being a firearm. That's a felony offense. Bond is going to be set at $5,000. Charged with one count of possession of a firearm by a person under the age of 18. Well, that's a misdemeanor. Bond is going to be set at $3,000. Finally, you're charged with one count of misdemeanor possession of marijuana. Bond is going to be set at $1,500. Because of the felony offense, you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Glover?
What's my total for the bond?
$12,000.
All right, thank you.
You're welcome, sir. Mr. Hosher?
Yeah.
Sir, you're charged with two misdemeanor driving related offenses. The first is driving a vehicle on an expired tag, bond set at $500. And the second offense is driving a vehicle with the suspended or revoked license. Bond is set at $1,500. These bonds are set by schedule, which means they're automatically set. You're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Appreciate it.
You're welcome. Mr. Lewis.
Good morning.
Good morning, Mr. Lewis, sir. You're charged with 1 count of battery. This is a misdemeanor offense. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from an Eric Mann. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir. Thank you.
Okay, you're free to go back. Mr. Lowry. Mr. Lowry, sir, you're charged with 1 count of misdemeanor possession of marijuana less than an ounce. The bond is set for this offense by schedule, which means it's already set or automatically set at $1,500. You're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Sir.
You do qualify, Mr. Lowry. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back. Mr. Maderos. Mr. Maderos, sir, you're charged with 1 count of felony possession of a controlled substance. Bond is going to be set at $3,000. This is a felony offense, so you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Mr. Maderos, at least from what I read, it looks like you may have been close to having maybe some bad things happen to you. If you're in a situation where you believe that you may want to go through drug court, that is something that can be available to you. You don't have a criminal history. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, I'm going to find that you qualify for the appointment of a lawyer. I'm going to ask you to have a serious conversation with your lawyer about whether some kind of intervention is necessary for you. Okay, sir? All right, you're free to go back.
Thank you.
Mr. McQuarrie.
Good morning.
Good morning, Mr. McQuarrie, sir. You're charged with a number of serious offenses. You're charged with 1 count of aggravated assault. Bond is going to be denied at this point on that charge. Charged 1 count of criminal damage to property in the 2nd degree as a misdemeanor. Bond is only set at $5,000. Charged with 1 count of reckless conduct as a misdemeanor. Bond is going to be set at $3,000. Charged with 1 count of violation of Georgia Controlled Substance Act. Bond is going to be denied at this point. You're charged with 1 count of use or possession of drug-related objects. Bond is going to be set at $1,500. That's a misdemeanor. You're charged with one count of simple battery. Bond is going to be set at $4,000. That's also a misdemeanor. You're charged with a felony count of false imprisonment. Bond is going to be denied. Another drug-related charge, violation of Georgia Controlled Substance Act. Bond is going to be denied on that felony. And finally, possession of a weapon during the commission of crime, which is a felony offense. Bond is going to be denied. There's going to be a stay away provision on this bond to stay away from a Taylor Collier. Do you understand that, sir? I'm sorry.
Yes, sir.
Your preliminary hearing date is going to be set for November 9th at 8:30 in the morning. You're going to also have a bond hearing date set for November 11th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Sir.
You do qualify, Mr. McQuarrie. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. McKinney?
Yes, sir.
Mr. McKinney, sir, you're charged with one count of misdemeanor theft by taking. Bond is going to be set at $2,000, and one count of simple battery. Bond is going to be set at $4,000. These are both misdemeanor offenses, but there's going to be a stay away provision on this bond to stay away from a Demetria Lawrence. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. McKinney. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Thank you, sir.
You're welcome. Mr. McNeil?
How you doing?
I'm doing well. Mr. McNeil, sir, you're charged with 3 drug-related offenses, okay?
Yeah.
So for the first violation of Georgia Controlled Substance Act, charge, possession of marijuana over an ounce, bond is going to be set at $5,000. For possession with intent to distribute or sell, that's another felony offense. Bond is going to be set at $10,000. And then possession of MDMA as simple possession, bond is going to be set at $3,000. These are all felony offenses. So you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. McNeil. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
Yes, sir. So total bond is 18,000?
Yes, sir. All right, you're free to go back. Mr. Nguyen. Mr. Nguyen, good morning, sir. You're charged with one count of battery. Bond is going to have to be denied at this point pursuant to Georgia statute 17-10-1 because it looks like you're on probation. I think I got a copy. There's going to be a stay away provision on this bond to stay away from a Sanyata Young. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. Don't normally have misdemeanor bond hearing dates, but that date can be held, or that hearing can be held on November 8th if necessary, but your lawyer has to file the appropriate paperwork to put the state on notice. Now, let me explain to you about this statute as to why your bond is being denied right now. Normally on a misdemeanor offense, you have a right to a bond. However, if you're on probation and you're charged with a misdemeanor that involves violence, bond has to be denied at that initial hearing. Doesn't mean you can't get bond tomorrow. Doesn't mean you can't get bond on Monday. It just, I can't set it at the initial hearing. Okay,
I'm just trying to make it to my brother's wedding next week. So what are my next steps?
so speak to your lawyer about seeing if they'll do sometimes what they call a bond waiver, where you waive your hearing, they consent to a bond, you get out, your case goes over to state court, and everything moves along. But that is the position that you're in right now. But like I said before, it's not something that where you have to wait until November 8th. It's just they don't allow the first judge to set bond under those circumstances.
Okay.
Okay.
And, yes, and this person that I'm not allowed to see, they can also dismiss that, correct?
Well, what happens is they can request for that to happen, but the solicitor's office makes their own independent determination, because, you know, there have been people who on one day say, I want this person to be released, and then the next day that person kills them. So they look into it. They will look into it. They will look into it. So it's not impossible, but I'm not gonna make you believe that it's just as simple as this person saying, I don't want to prosecute, and then that's what happens. Okay.
Okay, that's all right. Thank you.
Okay. Now, did you want me to appoint a lawyer to represent you?
I believe I have a lawyer.
Huh?
I have a lawyer.
Okay. Make sure you speak to your lawyer as quickly as possible and see if your lawyer can get in contact with someone over in the solicitor's office, and so they can at least discuss your case. Okay.
Thank you, sir.
All right, you're free to go back. Mr. Please. Mr. Please, sir, you're charged with 1 count of obstructing an officer. That's a misdemeanor offense. Bond is going to be set at $2,000. You're charged with 1 count of loitering or prowling. It's also a misdemeanor offense. Bond is going to be set at $1,000. You're charged with 1 count of possession of a weapon during the commission of a felony. I'm setting the bond at $10,000. You're charged with 1 count of possession of marijuana more than an ounce. I'm setting the bond at $10,000. And you're charged with 1 count of possession with intent to distribute marijuana. I'm setting the bond at $10,000. These, because of these felony offenses, you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you have your own lawyer?
I plan on getting one.
Okay. Do you have any questions for me, sir?
How much an hour?
$33,000.
All right, that's fine. Appreciate
Okay,
it.
sir, you're free to go back. Mr. Skillings.
How you doing, man?
I'm doing well. Mr. Skilling, sir, you're charged with 1 count of affray and 1 count of public drunkenness. There's going to be $1,000 bond set for each offense, and these are both misdemeanor offenses. You're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you have a brother named Elijah?
Yeah, that's my brother. Yeah.
Okay. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir, I do.
I'm sorry?
No, sir.
Okay, you're free to go back, Mr. Skillings.
All right.
Mr. Talbert. Good we're in the afternoon hour now. Mr. Talbot, sir, you're charged with 1 count of criminal trespass. This bond has been preset, and I'm gonna leave it the way that it is. It has the fee amount attached to it, so it's gonna sound strange. Okay, it's $530. Possession of marijuana less than an ounce. It says $1,135. I'm just gonna leave it the way that it is. You're charged with 2 felony offenses, both involving possession of a Schedule 1 narcotic, and I'm setting the bond at $5,000 apiece for each of those offenses. Because of the felony offense, you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Talbot. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. This is my first offense, my first time getting in trouble. I was trying to see, could I get a signature bond?
No, sir.
Can you tell me how amount of bond there?
It looks like it's gonna be $16,600, or I'm sorry, $16,060.
$60.
Hold on, I'm sorry. Math is all off. $16,665.
$16,665.
Yes, sir. Okay, you're free to go back, Mr. Talbot. Mr. Thomas.
Good morning, y'all.
Good morning, Mr. Thomas. This is your lucky day. You've been charged with 1 count of driving under the influence, but that charge is going to be dismissed because the officer did not place anything in the narrative about any reason that you could be suspected of driving under the influence.
Thank God.
The improper lane change, the officer did make out a probable cause for that. So the driving under the influence charge, that WA is going to be dismissed. The improper lane change, that's a misdemeanor. You're going to have a bond set at $500. You're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you receive a new court date in the mail. Now, it's important for you to understand, Mr. Thomas, that even though it's getting dismissed today at this hearing, doesn't mean this charge can't be brought back by the solicitor's office. And we most likely will get with the officer and make out probable cause. You did not fill the form out. Does that mean you intend to hire your own lawyer?
Yes, I probably will in the near future, if need be so.
Okay. All right. Do you have any questions for me?
Yes, I do, if I may ask you, if allowed.
I can't discuss the facts of your case.
Oh, okay. No.
Oh, so you said no?
No.
Okay, you're free to go back, sir.
All right, thank you.
You're welcome. Mr. Webb. Mr. Webb, sir, you're in the same position as the other person. You're charged with robbery by sudden snatching. which is a felony offense. And it's not a robbery in the classic situation. It appears to be an argument, and people decided to act less than like an adult. So I'm gonna set a bond at $7,500 for the felony of robbery by sudden snatching. I'm gonna set a bond of $5,000 for the simple possession of the VGCSA. There's gonna be a stay away provision on this bond to stay away from a Johnny Wiggins. Do you understand that, sir?
Yeah.
Your preliminary hearing date is gonna be set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Webb. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
It's worth an ask. I'm really don't have no money, so is there any possible way that you could just lessen the fee just a little bit if you can?
I'm not, and I'll tell you why. Again, this goes back to what I've said. You're an adult. Miss Wiggins is an adult. We have people that have guns being pointed in their face, their back doors getting kicked in. We don't need law enforcement to be out refereeing arguments and disputes between adults. I mean, it says the allegation is that you took her phone and put it in your pocket and wouldn't give it back. Why do the police have to come out for that?
That was the case and wasn't the case, sir. I know you're not going through the details of it, but
I understand, but I'm just explaining to you that everybody has disputes in their relationships and their lives.
right.
How they deal with it determines a lot. We just don't have the resources to keep coming out dealing with adults that don't know how to act like adults. So, sir, I need you, hold on, I'm gonna let you speak, I promise. I need you to understand that the next time you're in a situation where there's a dispute, try to exit out of it. Okay, so I interrupted you, Mr. Webb. Go ahead.
Yes, sir. I know it's part of the facts a little, but I had to. It's part of that. Actually, it's all right. Actually.
Okay. All right, sir. You're free to go back.
All right. And you said my bond was what was my bond again, sir?
$7,500 for the robbery by sudden snatching, and $5,000 for the violation of Georgia Controlled Substance Act.
Was that 13?
Yes, sir. No, it's 12.
Well, and I'm entitled to a lower percentage pay rate on it, or I gotta pay the whole
No,
fee?
you can go through a bonding company and pay a percentage of the bond amount. And again, I think there's 5 or 6 bonding companies that are authorized to write bonds in this county. You should contact each one of them, because some will work with you. They'll put you on a payment plan. It's a competitive business. But you have to do that legwork.
All right.
Okay,
Thank
sir. You're welcome. Mr. Wells. Mr. Wells, sir, you're charged with 2 felony drug-related offenses. One is possession of marijuana over an ounce. I'm denying bond at this point on that charge. And you're charged with 1 count of possession with intent to distribute marijuana. I'm denying bond on that count. You're charged with 1 count of driving on a suspended license. I am setting a bond at $1,500, and you're charged with 1 count of following too closely. I'm setting the bond at $500. Your preliminary hearing date is going to be set for November 9th at 8:30 in the morning. That date will get, well, actually, also setting a preliminary hearing date for you. Strike that. I'm setting a bond hearing date for you for November 11th at 8:30 in the morning. Preliminary hearing date is set for November 9th. Would you like me to see if you qualify for the appointment of a lawyer?
I want to say, is there anything I can do? Cause I started work November the 7th, and I'll be able to pay everything. I was trying to see why my bond got denied.
It says that you're on bond from an arrest March 1st of this year in Clayton County for possession. Hold on. Says purchase, possession, manufacture, distribution, or sale of marijuana, and driving on a suspended license, and possession or use of drug-related objects. So 7 months later, you're arrested again on similar charges. You don't have to raise your hands, sir. Sir, I'm going to let you speak, okay? You asked me a question. I just answered it. Now, what is it that you wanted to tell me, Mr. Wells?
I was gonna say that the last charge that's on my record, it was not mine in my possession. It was on somebody else. I just got charged with it. It wasn't mine. They took their charge. They charge. It was in their possession.
Okay. I'm explaining to you why I denied bond. Now, if there's something that goes behind that, I've appointed a lawyer to represent you. That could be brought to my attention, and you can get a bond. So I am charged when I'm deciding whether to release a person on bond. I have to decide whether that person is a danger to the public safety, or whether that person may commit another offense while on bond. If I see that you were arrested in March on drug-related charges and driving on a suspended license, and now you're arrested here in October on drug-related charges and driving on a suspended license, I gotta look behind that.
Can I say one more thing?
Yes, sir.
I thought my license was getting back valid. I thought it was almost a year from my first DUI.
Sir, I again, that's why we appoint lawyers. If your license is still showing as suspended, you know you have to take steps to reinstate your license. It's not just, it doesn't automatically just become valid again. Okay. Anything else, sir?
Thanks.
All right. Mr. White.
Good afternoon.
Good afternoon, Mr. White, sir. You're charged with a number of offenses. You're charged with simple possession of cocaine. That's a felony offense. Bond is going to be set at $3,000. You're charged with possession of marijuana with the intent to distribute. Bond is going to be set at $10,000. You're charged with possession of marijuana less than an ounce. Bond is going to be set at $1,500. You're charged with having a dangerous drug outside of the container, which is, just so you know, if you have anything that has a prescription on it, you're supposed to keep it in the prescription bottle. And if it's found outside of the prescription bottle, that forms the basis of this charge. That's a misdemeanor. Bond's going to be set at $3,000. Charge one count of simple battery. That's a misdemeanor. Bond is going to be set at $4,000. and you're charged with 1 count of criminal trespass. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from a Jada Jackson. Do you understand that, sir?
Yeah.
Your preliminary hearing date is going to be set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me? I'm sorry, sir.
The total?
$24,500.
Damn. Okay, so you and I have a question. Okay, I'm not from here, right?
Okay.
I'm from New York.
Okay.
And I have court on the 9th in New York.
Okay.
Damn.
So, Mr. White, do you have anyone that can, do you have a lawyer up in New York?
I have a lawyer in New York.
Do you have anybody that can let your lawyer know that you're in custody?
I have to call around, but they only let me get 3 numbers out my phone, so I have to see.
Okay, so if you're not able to get in contact with your lawyer, your case may go into bench warrant status if they don't know about this arrest. However, the fact that you were in custody here would form the basis for your not appearing in court up in New York. However, if there was any reason that you're placed on bond up in New York and you're told not to violate any other laws, this may form the basis of your having your bond revoked up in New York.
Oh, no, I don't have no bond in New York. They let me out RR.
Okay. All right, sir.
So you said 27,000? I'm at 20. The total?
$24,500.
Thank you, Your Honor.
You're welcome. Okay. Mr. Vasquez, sir, can you hear and understand the interpreter?
Señor Vázquez, buenos días. ¿Puede usted oír y entender al intérprete? Your Honor, the interpreter is not sure if you heard me. Shall I repeat?
Yes, please.
Señor Vázquez, buenos días. ¿Me está oyendo?
Sí, sí, lo estoy escuchando.
Okay. ¿Puede usted oír y entenderme?
Sí, sí.
Your Honor, the defendant has responded affirmatively. He can hear and understand me.
Thank you. Mr. Vasquez, my name is Brad Gardner. I'm a judge in Magistrate Court of Clayton County.
Señor Vázquez, yo soy el juez honorable Brad Gardner. Soy un juez aquí en el Tribunal Menor de la Sala Menor del Tribunal de Primera Instancia del Condado de Clayton.
This is your first appearance hearing. We're not here to take a plea in your case or to have a trial of your case.
Esta audiencia es su comparecencia inicial. No estamos acá para que usted se declare ante acusaciones, tampoco para llevar su caso a juicio.
We're here for me to tell you the charges that have been placed against you.
Estamos aquí para informarle de las acusaciones formuladas en su contra.
To tell you of any future court dates.
Para informarle de las audiencias futuras que están programadas.
To see if you will require the assistance of an attorney.
Para determinar si usted requiere el asesoramiento de un abogado.
And to give you some basic understanding of your rights.
Y también para explicarle básicamente lo que son sus derechos.
You've been charged with 1 count of pedestrian in the highway.
A usted se le están acusando de una infracción de peatón en la vía de tránsito.
And that basically means that you were seen crossing a roadway not in a crosswalk.
Eso significa básicamente que a usted lo observaron cruzar una calle fuera de la zona peatonal.
The bond for this offense, Mr. Vasquez, is $500.
La fianza para esa infracción, señor, es $500.
You're going to have a preliminary hearing date set for November 8th at 8:30 in the morning.
Su audiencia preliminar estará programada para el 8 de noviembre a las 8:30 de la mañana.
That date will get waived upon your bonding out, and you'll get a new court date in the mail.
Esta audiencia quedará renunciada una vez que usted salga en libertad bajo fianza y recibirá la notificación de su nueva fecha de audiencia por correo.
Before I tell you a little bit more, would you like for me to see if you qualify for the appointment of a lawyer?
Antes de decirle un poco más, señor, quiere que yo determine si usted reúne los requisitos para un abogado de oficio.
No sé.
Yes.
No.
I'm going to appoint a lawyer to represent you, Mr. Vasquez.
Señor, le voy a poner un abogado de oficio para que lo represente.
Now, as it relates to the bond, you can post bond in one of three ways.
Ahora bien, señor, en cuanto a la fianza, puede pagar la fianza en una de tres maneras.
The first way will be using a bonding company.
La primera manera sería tramitar la fianza a través de una compañía de fianzas.
You will pay a fee to that company, which is normally a percentage of your bond.
Usted pagará una tarifa a la compañía que suele ser un porcentaje de la fianza total.
The fee that you pay to that company will not be returned to you.
Y la tarifa que le paga la compañía no se le devuelve.
You can post the entire amount in cash to the sheriff's department.
Puede depositar la fianza total en efectivo en la comisaría del sheriff.
The sheriff's department will hold that money and then return it to you when your case is over.
La comisaría del sheriff guardará el dinero y luego se lo devolverá una vez que se ha concluido su caso.
If you have property within Clayton County that has a value of at least 3 times the bond amount, you can use that property as collateral for your bond.
Si tiene una propiedad con un valor adquirido de por lo menos 3 veces lo que es el valor de la fianza, puede usar como garantía esa propiedad para la fianza.
The sheriff's department will place a lien on that property and then remove the lien when your case is over.
La comisaría del sheriff impondrá un gravamen en esa propiedad y luego le quitará el gravamen una vez que se concluye el caso.
Now, this is where I tell you of some of the rights that you have.
Ahora, este es el momento que le explico a algunos de los derechos que tiene.
During this and all other proceedings, you will have the following rights.
Durante esta diligencia judicial y cualquiera en el futuro tendrá los siguientes derechos.
To the presumption of innocence.
Tendrá el derecho a la presunción de inocencia.
To indictment by a grand jury for most felonies or by accusation for misdemeanors.
El derecho a que se le emite una acusación formal por medio del gran jurado cuando se tratan de delitos graves o que proceden en su contra por medio de acusación general cuando se trata de delitos menores.
To a speedy and public trial by jury.
Tendrá derecho a un juicio público y sin demora ante un jurado.
To see, hear, and question witnesses who are called to testify against you.
Tendrá también el derecho de ver, a escuchar y a contrainterrogar los testigos convocados a declarar en su contra.
To compel the attendance of witnesses to testify on your behalf.
El derecho de obligar la comparecencia de testigos para que declaren a su favor.
To testify on your own behalf or offer evidence in your own defense.
El derecho de declarar en representación propia o presentar pruebas para su defensa.
And you have the right to have an attorney represent you.
Y también, señor, tendrá derecho a un abogado para representarlo.
And in your case, I have appointed an attorney to represent you.
En el caso suyo, ya designé un abogado de oficio para usted.
Do you have any questions for me, Mr. Vasquez?
¿Tiene usted alguna pregunta para mí, señor Vázquez?
No, es todo.
No, that's all.
Okay, sir, you're free to go back.
Muy bien, señor. Your Honor, you said that my court date is the 8th of November?
Yes, sir, but if you bond out, that date will get waived and you'll get a new court date in the mail.
Sí, señor, pero si usted deposita la fianza y sale, entonces esa audiencia quedará renunciada y le notificará por correo de la fecha de la próxima cita judicial.
Okay, sir?
¿Está bien?
Está bien.
That's fine. Okay.
Okay, sir, you're free to go back.
Muy bien, señor, ya se puede retirar. Gracias.
Thank you, Ms. Tolles.
Thank you so much, Your Honor. I hope you have a great day.
I hope you have a great day.
Take care.
Goodbye. Okay, let's switch over to the ladies. Well, no, let me read the script for everyone. I need everyone to stand up. Okay, this is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the resumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence to your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, would everyone please raise your right hand? Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God? Okay, now let's begin on the ladies' side with Miss Bourque, Bourque. Miss Bourque, ma'am, you're charged with 1 count of simple battery. This is a misdemeanor offense. Bond is going to be set at $4,000. There's going to be a stay away provision on this bond to stay away from a Aaliyah Tyree, and Aaliyah, Aleyaa, Tyree. Do you understand that, ma'am? Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I wanted to ask the commercial. I kind of heard a little bit of it. The commercial, that's where you did the percentage of the.
Yes, ma'am. And I'll explain it to you. And it's fine to ask questions. That's what I'm here for, to answer questions. So you got 3 options in how to post a bond. One is what we call commercial bonding, and that's generally known as a bonding company. Okay. So I think there are 5 or 6 bonding companies that are authorized to write bonds here in Clayton County, and you can go to either one of them. I encourage you to see all of them, because each one will quote you a different fee. Whatever fee they quote you is generally based upon a percentage of your bond, and it's generally about 10 to 12% of your bond. Whatever you pay to them as a fee, that stays with them. They will not return it. You can post the entire amount to the sheriff's department in cash, and the sheriff's department will hold that money. And then when your case is over, they'll return all of the money to you. Finally, if you have property, real estate that has at least 3 times equity of the bond amount, you can post that property. Sheriff's Department will place a lien on that property, and then when your case is over, they will remove that lien and you can go about your business. Okay. Any other questions, ma'am?
I noticed that you said that I can talk to those bonding companies. How would I go about that part?
So there should be a list, and I've seen it before, but I don't know exactly where it is. You could just ask one of the deputies and they'll direct you. But generally there's like a little slip of paper that has the bonding companies, their names and the telephone numbers. Or when you get the opportunity, I don't know if you've had the opportunity to speak to any family members yet, but if you have the opportunity to speak to a family member, it may be easier for that family member to make the phone calls, because they can just sit and make the calls. You may not necessarily have that amount of time on your hands, but you now know what the bond amount is. And I just have to caution you that it's going to be a little bit higher than the $4,000, because the Sheriff's Department is required by law to add certain fees, but they have the fee schedule and I don't. So because they have the fee schedule, whatever bond I set, they add the fee to it based upon the schedule that they have.
Okay. And just to make sure, even though this is my first offense, it's going to be set that high. Okay.
Even though it's your first offense, it's going to be what?
I said, so even though this is my first offense, it's still going to be set that high to 4,000, correct?
Ma'am, this is what I set every simple battery to, and I'll tell you the reason. You have a choice of what you do with your hands. You have a choice of what you do as it relates to other people. You can't imagine how many batteries I see in a week, because people get into arguments and they decide they want to fight each other. We just don't have the resources to have law enforcement coming out to referee fights between adults when people are getting shot and their doors are getting kicked in. And we need those law enforcement officers there rather than at your house. Does that make sense to you? So the next time that there is a disagreement, hopefully a cooler head will come about and somebody will leave and go drive around or whatever, as opposed to thinking that we're going to tie up resources because we have a disagreement. Okay, so that's the public policy behind it. Okay, anything else, ma'am?
No, that's all.
Okay, ma'am, you're free to go back. Miss Crankshaw.
Yes, sir.
Miss Crankshaw, ma'am. Okay. This is your third charge with an allegation of driving under the influence of alcohol, which means that it makes this a felony offense. And with respect to that, the bond goes up. And I see that you're not working. Are you, and I'm sorry if I do not mean to offend you by asking this question, but are you retired, or is it you're just not working, or what's
I'm retired. My husband died 10 years ago, and I really had no problems before that, but not that that's an excuse, but
I understand.
No, I'm not working. I live in a government Section 8 facility, and so I'm able to live on a small Social Security check, and it's small. It's less than 700 right now, because I worked for private schools more than public.
I understand.
And they didn't pay in the Social Security, you know, they didn't take it out, so I didn't get it back.
All right. Okay. This is what I'm going to do, ma'am. I'm going to set your bond at $5,000, which is the amount that I would normally set for a first time DUI. But it's still going to remain a felony offense. So you're charged with DUI as a third offense. That's a felony. I'm going to set the bond at $5,000. You're charged of following too close. I'm going to set the bond at $500. And you're charged with an open container violation. I'm going to set the bond at $500. You may want to consider entering the DUI treatment program. It looks like that you have been assigned to that before out of Noonan.
Yes, sir.
Are you still in that program, ma'am?
No, but may I ask you a question?
Yes, ma'am.
I don't know where, but I've heard places where you can go to get help and stay there, or either if you consider that.
Well, I can't order that here at first appearance. What I can do is I can appoint a lawyer to represent you. Do you want me to do that?
Yes, sir, please.
Okay, I'm going to appoint a lawyer to represent you and speak to the lawyer about your situation, because they will most likely be able to work something out fairly quickly to move you into a treatment facility. But there are going to be things that you're going to have to agree to, but that'll be a discussion between you and your lawyer. And as it relates to where it goes with the district attorney's office, they're going to have to agree, of course, but that's where this becomes an issue of negotiation and discussion as opposed to having an adversarial stance. Because this is a felony offense, you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any questions for me, Ms. Cranksaw?
I think I asked the only thing that's all I can think of right now. Thank you.
You're welcome. Stay in contact with your lawyer, ma'am, and you know, I wish the best for you.
Thank you.
Okay. Let's bring up Ms. Davis. Ms. Davis, ma'am, you're charged with 1 count of terroristic threat as a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a
Thank you so much.
You're welcome. There's going to be a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, ma'am, you're free to go back.
Thank you again.
You're welcome. Miss Finn? Miss Finn, ma'am, you're charged with 1 count of simple battery as a misdemeanor and 1 count of giving a false name, address, or date of birth to law enforcement. These are both misdemeanor offenses. For the simple battery, bond is going to be set at $3,000. For the giving false name, address, or date of birth, bond is going to be set at $2,000. You're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay,
No.
ma'am, you're
Thank
free.
you.
You're welcome. Ms. Trotter?
Yes, sir.
Good morning, Ms. Trotter.
Morning.
Ma'am, you're charged with 1 count of knowingly driving a vehicle with a suspended registration. Bond is going to be set at $500. That's a misdemeanor offense. 1 count of driving a vehicle with no insurance. Bond is going to be set at $1,000. And 1 count of driving a vehicle with a canceled license. Bond is going to be set at $1,000. Because these are all misdemeanor offenses, you're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like me to see if you qualify for a lawyer, Ms. Trotter?
Yes, please.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I'm not.
Okay, ma'am, you're free to go back. All right, is that the last person we have on the lady side?
Yes, sir.
Okay, thank you. Let's switch over to the male side, Mr. Banks.
Yes, sir.
Mr. Banks, sir, you're charged with 1 count of possession of firearm by a convicted felon. I have a concern, Mr. Banks.
Yes.
It looks as though you've had a number of recent arrests in Atlanta. It looks like you were arrested on August 8th of this year. Possession of firearm and knife during the commission or attempt to commit felonies, aggravated assault, receipt of possession, transport of firearm by a convicted felon. Because of that August arrest, I'm going to deny bond at this time on this offense. And this is going to give at least your lawyer, or to give a little bit more perspective to see whether you should remain in custody or whether you're a person that is a good candidate for being out on bond. Your preliminary hearing date is going to be set for November 9th at 8:30 in the morning. I'm going to set a bond hearing date for November 11th at 8:30 in the morning. Do you want me to see if you qualify for the appointment of a lawyer?
Sir.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. And I don't know. Let's see. So it looks like I'm going to be doing the preliminary hearings that week. And so you can tell your lawyer that the one thing that I want to know is the status of your case in Atlanta, that August arrest.
I'm just out on bond for it. They haven't the victim told my public defender and the judge that day I went to court that it wasn't me and it don't look like me. The person that shot at her. And she was on my behalf at court, everything recorded.
Okay. Well, that's the kind of stuff that I want to have a better understanding of, because you do have a little bit of a history, and it does point towards violence related issues. So one of the things that I have to be concerned about is public safety, and having this type of weapon in your possession and seeing.
It wasn't in my possession though.
Sir. Possession can be constructive or actual. They're alleging constructive. Meaning, okay, meaning they're not saying you're busting out of the house with a gun in your hand. That's not the allegation. Allegation is that this weapon was in a place where it could reasonably be assumed or presumed that you had some kind of custody or control over it. Those are the things that are going to have to get worked out. And I'm just being honest with you so that you can have a conversation with your lawyer. And so when we show back up on the 9th, everybody's ready to go.
All right. Thank you, sir.
All right. You're free to go back.
All right, thank you.
You're welcome, Mr. Bennett. Mr. Bennett, sir, you're charged with 1 count of simple battery. I'm going to set the bond at $3,000. You're charged with 1 count of criminal trespass. I'm going to also set the bond at $3,000. These are both misdemeanor offenses. So you're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Now, there's going to be a stay away provision on this bond, a stay away from a Maya Bennett. And I understand that that's a relative, correct?
Yeah.
Do you all stay in the same household?
Yeah.
Okay. Well, that's going to have to be something that for the short term is going to have to get changed, unless you go through the Solicitor General's office, and if Amaya Bennett says, hey, I don't have any problems with this person being under the same roof, then, you know, they can petition the court to modify the stay away provision. And 9 times out of 10, that happens. But just so you understand, whatever disagreement that led you to come before me today, you're going to be able to bond out today. And we don't want that to flare back up at night. Okay. Do you want me to see if you qualify for the appointment of a lawyer? Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Not at the moment, no.
I'm sorry, sir.
No.
Okay, you're free to go back. Mr. Gray. Mr. Gray, sir, good morning, sir. You're charged with 1 count of possession of Xanax pills. That's a felony offense. I'm denying bond on that at the moment because it appears that you're still on probation. You're charged with 1 count of driving on a suspended or revoked license. Bond is going to be set at $1,500. You're charged with 1 count of possession of a firearm during a crime. That is also a felony offense that I can't set bond because it appears that you're still on probation. And so, Ms. Wesley, that's no bond pursuant to 17-10-1 for both of the felony offenses. And then you're charged with 1 count of a tag obstruction, and bond is going to be set at $500. You're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That will be most likely by Zoom. I'm also going to set a bond hearing date for November 11th at 8:30 in the morning. That will also be by Zoom. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I just got a quick question. Just real fast. Basically, as far as on my probation, I'm on non-report, and I actually don't have an actual assigned
probation officer.
Yes, sir.
So,
so how would I go about as far as me letting my family know to contact somebody from, you know?
So, suspended sentences and non-reporting probation both count as being on probation.
Right.
So if you're trying to get this matter taken care of as quickly as possible, there should be like a last office. I mean, is it non-reporting out of Clayton County, non-reporting out of Fulton County? Where is it non-reporting out of?
I was actually assigned out of Fulton, but I got transferred to Clayton. So this was like around COVID time. So I wouldn't say my last time reporting was probably like 4 or 5 months ago, something like that. And then that's when I got put on non-report and haven't spoke to anybody since then. I don't have a sign officer or anything. So
you most likely will need to contact the probation office here in Clayton, but have that conversation with your lawyer, because I'm telling you what I believe, but the lawyer will tell you what the lawyer knows. Okay. And that's the best that I could give to you. Okay. Anything else, sir?
No, that's it.
Okay, you're free to go back. Mr. Jarrett.
Good afternoon, Your Honor.
It's still morning. I'm working fast.
Good morning. I'm sorry.
Thank you, sir. Mr. Jarrett, sir, you're charged with 1 count of possession of a firearm with an altered serial number. That's a felony offense. I'm going to set the bond at $5,000 for that. You're charged with 1 count of misdemeanor possession of marijuana less than an ounce. I'm going to set the bond at $1,500. And you're charged with 1 count of loitering or prowling. I'm going to dismiss that count. You're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. I just want to make sure the total amount for my bond was $7,000 altogether, correct?
$6,500.
All right, thank you.
But again, it'll be a little bit higher because the Sheriff's Department is required to add fees
Yes,
to the
sir.
bond. Okay. All right, sir. You're free to go back.
Thank you.
You're welcome. Mr. Pride. Mr. Pride, sir, you're charged with 2 misdemeanor counts of terroristic threats or acts. I'm going to set the bond at $4,000 for each of those counts. And you're also charged with 1 count of simple battery. That's also a misdemeanor. I'm going to set the bond at $3,000. There's going to be a stay away provision on the bond, to stay away from a Robin Taylor and a George Taylor. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Can you repeat my
It's $11,000 without the fees added on as your total bond. Any other questions, sir?
No, sir.
Okay, you're free to go back.
Thank you, sir.
You're welcome. Mr. Proctor. Hold on one minute, sir. I'm sorry. Mr. Proctor, sir, you're charged with 2 misdemeanor offenses. One is driving a vehicle with no insurance. Bond is going to be set at $1,000. And the second count is having an open container violation. Bond is going to be set at $500. Because these are both misdemeanors, you're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Oh,
Okay. Do you have any questions for me, sir?
no, I'm good.
Okay. Have a good day, sir. Mr. Skillings. Mr. Skilling, sir, you're charged with 1 count of affray. This is a misdemeanor offense. Bond is going to be set at $1,000. You're also charged with 1 count of public drunkenness. This is also a misdemeanor. Bond is going to be set at $1,000. Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Oh, Your Honor.
You said no?
Yes. No, Your Honor.
Okay, sir, have a good day. You're free to go back.
May I ask you a question?
Yes, sir.
Can you explain to me what a fray is?
Affray is basically fighting in public. So if I were to attack you, that could be a simple battery or a battery. If you and I agree to engage in a fight, then that's a fray. So it's not saying that one person caused the fight versus another. It's saying they both agreed to fight. And if it's in public, it becomes a fray.
Can I ask you one more question?
Yes, sir.
Is there any possibility I could get a signature bond?
No, sir.
All right. Thank you, Ron.
You're welcome. Mr. Enrico Thomas. Good morning, sir. Mr. Thomas, you're charged with 1 count of disorderly conduct. That's a misdemeanor offense. I set the bond at $1,500. You're charged with 1 count of obstructing an officer. I set the bond at $3,000. And you're charged with 1 count of possession of marijuana more than an ounce, which is a felony offense. And I'm denying bond at this point because it appears as though you're still on probation. You're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. You're going to also have a bond hearing date set for November 11th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, you said the bond was 4,500.
Yes, on the misdemeanors.
Okay. But the felony, what did you say about reaching somebody? Because my disposition is actually it ends tomorrow.
I saw. I mean,
Yeah.
you're that close.
They said don't explain, so I mean it's not really gonna matter.
No, don't explain. But I'm gonna say this to you, Mr. Thomas. From what I read, this was something that was totally avoidable.
Yeah, dealing with my mama, like I was just protecting my mama. That's all. She called me and I came.
I understand, but I'll say this. Somebody should have said, hey, he's on probation. He's about to get off. Let's let this ride for 5 days and then come back and address it. But my hands are tied. Now, the way the statute works is this. I can't set bond at this stage. Doesn't mean your lawyer can't get with the district attorney's office tomorrow, day after tomorrow, Monday or whenever, and they reach an agreement. They do what they call consent waivers, consent bonds, consent bindovers, all of this stuff to move the case along, and you get a benefit where they agree to setting a bond on this. So speak to your lawyer about it, especially about the facts and circumstances of your case, and the lawyer may be able to work something out that gets you out of here very shortly.
So you said have somebody reach out to my PO and let them, what did you say?
So two things. Your PO can contact the DA's office and say, hey, this person has been fined. I don't have any problems with this person. If y'all want to put this person back on the street, I'm not going to place a hold on them. Your lawyer may go to the district attorney's office and say, these are the facts and circumstances that led to my client's arrest. We're willing to work something out on a short term so that he can get a bond and get back out on the street, and then we can deal with this later.
Okay, so I got one more question. Let's say if I get my folks to reach out to the PO or something like that, and they decide not to put a hold on, when would I won't get a bond until my next bond hearing for that felony?
No, and that's why you need to speak to your lawyer, because the lawyer is the person that can advocate on your behalf between the probation officer and the district attorney's office. Okay? So if your folks theoretically call your PO, first thing the PO is going to do is say, well, I got to figure out what happened. And that may take a week. It may take 2 weeks. And then we're back up. I see you again while your PO is still trying to figure out what happened.
I mean, but by then, probation will be terminated. It will be over.
So this occurred prior to your probation being terminated. That's why you're being held. So it doesn't just fall away.
No, correct.
Okay. So just speak to your lawyer and start with your lawyer. I'll start your lawyer. Okay, sir.
They'll be in touch as soon as when? Or I have to wait till that? Or they'll just
so my understanding from what I've seen is that they set up video visits. So they'll arrange through the jail to have a date and time to speak to you. So make sure you pay attention to that and that you're on that call, because that's when they can get the most information and get started. Okay?
The bond is $450 for the 2 misdemeanors.
Yes, sir.
All right, thank you.
You're welcome. Mr. Williamson. Mr. Williamson, sir, you're charged with 1 count.
Oh, shit.
Mr. Williamson, sir, this is being recorded and you are in court. Okay?
Yeah.
Thank you, sir. Mr. Williamson, you're charged with 1 count of forgery in the 3rd degree. This is a felony offense. I'm setting the bond at $5,000. You're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Although, let me see. No, okay. For some reason, I thought that there was a warrant showing for you, but it's not. That November 9th date at 8:30 in the morning will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, sir, you're free to go back. And finally, we have Mr. Charles Anthony Thomas.
Hello, good morning.
Good morning, Mr. Thomas. Sir, first I want to tell you that all of the rights and privileges that I discussed earlier, they apply to you in this context also.
Okay.
You are in sort of a special situation where the language is called being a fugitive from justice. And what that simply means is that there's a warrant for your arrest out of another state. And in this situation, it appears that it's Arapahoe, Colorado.
Arapahoe.
Arapahoe,
Yes.
Colorado. Okay. For contempt of court for failure to, it says comply. And there is a warrant number. I can give you the warrant number if you want the warrant number.
Yes, may I spin, please? Thank you.
Okay, the warrant number is W06. Wait, I'm sorry. Yes, 060605.
060605.
Yes, sir. 710.
Okay, I'm gonna repeat that to you one more time, sir.
Okay.
06060571.
Yes, sir.
Okay.
So, being in this status, you have a right to challenge the extradition because they said that they're going to come and get you. If you were to challenge the extradition, sometime between now and the next 90 days, there will be a hearing to determine whether you are the person named in the warrant and whether the warrant actually evidences or shows that this is a charge, that is a valid charge. If at the end of that hearing, the judge determines that you are the person named and that the charge is a valid charge, the judge will sign off on a writ, and sometimes it's called a governor's writ or different names for it, but the writ will then allow Colorado to come and pick you up. So from the date that the judge signs off on the order, there is a minimum of 30 days, maximum of 60 days that Colorado has to come and get you. The statutory period is 30 days. It could be sooner or it could be up to the 29th day. If Colorado decides, hey, we want to apply for an extension and that extension is granted, there's an additional 30 days added. If Colorado does not come and get you, then the sheriff's department will release you out of the front door, but the warrant is still valid. So you can walk out the front door. I'm gonna let you speak. Walk out the front door. 5 minutes later, you interact with another law enforcement officer. They run your information. They say, hey, you got a valid warrant. They take you back into custody. It starts all over again. Now, I interrupted you. Go ahead.
Okay, so what I was going to ask, so the second, after they file for the first extension, if they don't come pick me up that second time, then I get let go after 60 days.
Yes, sir.
Okay, all right. And then if I don't sign the extradition, then I'd have to wait up to 3 months to challenge this?
Yes.
Okay, cool.
Now, hold on. Oh, go ahead. I'm sorry.
So my next question was, I had it in my head. I'm so sorry. Do forgive me. So when was the warrant issued? What day was it issued? Do you have that information?
I do not have that information. It probably is within the files of the Fugitive Squad at the Sheriff's Department. Okay. Sometimes they'll have a date listed and sometimes they won't. In this situation, they don't have a date issued or listed. But now, today, you can decide to waive the challenge. If you believe you are the person named and you believe that possibly this warrant does exist out there, you can waive that. It doesn't mean you're guilty. You waive the right to challenge it. And that 30 to 60 day period starts to run today.
Yeah.
And so what I generally tell people is, one, no matter what, you need to get you a lawyer out in California. I mean, out in Colorado to represent your interests out there. Because of the whole COVID stuff and people not wanting to travel and things like that, I've seen where someone hired a lawyer and the lawyer was advocating on their behalf in what it's called the requesting jurisdiction, meaning Colorado in this instance. Get into contact with the district attorney or the prosecutor or the judge out there, and I say, you know what? Because this person has hired a lawyer and because this person is taking these steps, we're going to grant a bond. I can't grant a bond, but they can grant a bond. And if they grant the bond, they transmit that information to us and we release you out the front door.
Okay. All right. So the thing about why this is kind of funny to me is I've been here for the past 3 years. I haven't been out in Colorado since 2019. So I'm a little confused as to like why all of a sudden there was a warrant for my arrest. So I was trying to get the timing of it, at least when the warrant was issued, so I could at least tell my somebody that, hey, like I've been in Georgia for this amount of time. So I don't know how I could have gotten this charge.
Let me ask you this. Were you in Georgia on a charge that recently got resolved? Were you in Clayton County on a charge that it was, we call it disposed of, meaning it was either dismissed or you pled guilty to something?
Yeah, I've been to Clayco. It was for driving on a suspended license. That was also 3-4 years ago.
And you've been in custody since then?
Have I been here since then? No.
Okay. So generally, and I'm not gonna ask you to get into your details because this is being recorded. Generally, if there's a warrant for your arrest and out of another jurisdiction, and you are arrested on new charges, that warrant sits until whatever the new stuff that you have has been resolved. And then once the new stuff gets resolved and you're ready to walk out the door, that's when the warrant hits. So I don't know, and I'm trying to look up your situation. Let's see. So it looks like you had something in DeKalb. Were you in custody in DeKalb?
When?
It says 2014, 2015, looks like it was accused, meaning formally charged. And then it says 2019, you were arrested on driving while license is suspended or revoked. And says you were sentenced to 12 months of a suspended sentence. So have you been out of custody during any of this period of time?
Yeah, I've been out of I've been out of custody. Yes, I haven't been in jail now.
Okay. So it looks like it says the date of the warrant was October 14th of 2022.
That's when they issued the warrant. Wow. Okay.
Yeah.
Can you repeat that for me, sir? You said October
14th of 2022.
So it was issued just a couple of weeks ago.
Yes, it says Sheriff's Office of Centennial, Colorado. Does that make any sense to you?
Centennial, that's where Arapahoe County Jail is at.
Okay. So I don't know, but it looks like it says I don't know. It says failure to comply. I'll give you, it looks like there's a case number. It says 2019-3056.
056. Okay. Case number is 2019-3056, correct?
Yes.
Excellent.
Okay, so do you know what you want to do? Because it's the choice is yours, either to contest this or to and get a lawyer to represent you out in Colorado?
So when I was out in Colorado, I was in jail out there. And I had a lawyer that was helping me with my situation out there, and my mother has gotten in contact with him. So I guess hopefully he's going to do some things on my end. Do I need a lawyer for this side as well, or just for that side?
Just for that side.
Okay, all right, cool. I know there was another question I had. Do forgive me, I'm so sorry, Your Honor. Okay, so just to review my choices again, if I sign this now, then either at maximum I can remain in here 60 days, and as long as I don't get caught up in anything else, then I can be on the outs until Colorado either sends me something or says I need to come out there, right?
Right. And one of the things that you may want to consider, and maybe have this conversation with your lawyer, is that if you waive the hearing, the clock starts to run now for Colorado to come and get you.
Okay.
So that may give your lawyer extra leverage in working something out, because they know that if they don't, they're going to have to send somebody down here to get you.
Okay. And then in the case that I decide to fight this, do forgive me for cutting you off. I'm so sorry.
No.
In the case that I decide to fight this, it'll be a month to potentially how long before I could squash this?
See, and that's the thing. I couldn't tell you. You would get placed on a calendar, and I know that. I can't tell you when that will happen, but there is a statutory time limit for us to place you on a calendar also. But if you were fighting it, theoretically, Colorado has an extra 90 days to decide what they're going to do.
Okay, so beyond the 30 days for just signing, they'd have another 2 months on top of that 1 month.
Yes, sir.
Okay, all right. Yeah, I'll sign the waiver, and I'll get a hold of somebody on that end and make sure that I have a lawyer on that side.
Okay, no matter what, make sure you hire a lawyer out in Colorado to address this, because it appears that it's not, it's not like it's a murder warrant. It just seems like there's some kind of technical issue that may be able to get worked out.
Yeah.
Okay.
Yeah, going out there is what I got to do. That's not an issue.
Okay.
Is there any more? I'm sorry, sir. Is there any more information that any case numbers or any other things that I could possibly look up?
No, that's what I see.
Okay, cool. Thank you. So
I can do, there's a number for the sheriff's department if you want that.
Yes, please. That would help.
It's 303 795 4711.
4711, Sheriff's Department, Arapahoe. All righty.
Any more questions, Mr. Thomas?
I can think of at the moment, sir.
Okay. Have a good day.
Oh, I'm sorry, sir. So should I go ahead and sign this? Because I did want to sign it.
Yes, go ahead and sign it and give it to the deputies, and they'll send it to me and I'll sign it. And the clock will begin running today.
Good afternoon, sir. Sir, the court received additional information by way of a narrative supplement as well as the charging affidavit. And based on that additional information, the court does find probable cause for the 4 counts and the additional 23 counts of which Mr. Moses let me know yesterday that you were aware of. I do also find, based on probable cause being found, that there's an on-view violation of the probation that you are on, and I don't have that case number handy.
I have it, Your Honor.
Ms. Boudin?
2009 CF 568.
That is correct. The warrant on the violation of probation is going to be none. As to each of the 28 counts, your bond is going to be set in the amount of $1,000 on each count. So he has bonds on the new case, no bond currently on the violation of probation allegation based on the designation. Right, I'm not sure, Mr. Uding, that I have additional court dates for you. All right, has that been assigned to a division? All right. You're going to be in front of Judge Tom Young, and I'm sure they'll be assigning arraignment dates for you. Thank you very much, sir.
Thank you, Judge.
Thanks, Mr. Gizen. Right, the recall that I have next is Eliezer Torres. That's 2022 MM 2419.
Judge, he is not present in the courtroom. Apparently, he was having some behavioral issues this morning, and we'd like to waive if possible.
All right, thank you. He was present yesterday, vehemently disagreed with what was in the charging affidavit, but the court released him on pretrial release. I was informed after court that he was not eligible for pretrial release.
No, he refused,
Oh, he refused pretrial release.
and now he's having behavioral problems.
Okay,
So we could take him off pretrial release?
we're going to do that. The court's going to set bond the amount of $1,000 with the special condition of bond that he not return to the location at 1454 Turkey Lane. And I will appoint the office. Well, I think the public defender's office was appointed yesterday. Thank you. Right, State of Florida versus Joshua Williams.
Your Honor, I'm sorry. I thought we do have a private counsel here today.
I'm sorry, is that Mr. Lejean?
Mr. Richard Witters.
Mr. Witter.
Thank you, Your Honor. Ronald LaShawn for Mr. Witters.
Sorry about that, Mr. Lejean, I forgot you. All right, Mr. Lejean, your client is here on two separate cases. One is 2022 CF 3037 and one is 2022 CF 3041. Both of those cases were initiated by warrant. Mr. Lejean, is your client up to speed as to the allegations contained in the warrants?
We know what the charges are, and I haven't actually seen the warrants, only the warrant arrest, so I do not know what is actually in the warrant himself. We weren't able to find it online yet. The clerk may have not got it in, and but we have gone over what the charges are.
All right, thank you. The in 2022 CF 3037, there are 4 allegations. Judge Tennis has issued no bond on each of those 4 allegations. On 2022 CF 3041, there are 3 allegations. There are, and Judge Tennis has issued 0 bond on those allegations. I don't know whether the state of Florida will be requesting Arthur consideration, or even if these require that because of them being life felonies. Ms. Boudin, can you tell me? In 2022 CF 3037. Can you tell me the level of offense?
I'm showing 3 counts of F2s and 1 count of an F1. And I'm pretty sure the state is objecting to bond at this time, Your Honor, and would request a hearing on that.
What division are these cases assigned to?
These would be in our 6 crimes unit, Your Honor.
No, I'm asking which of the 3 trial divisions?
Oh, I'm sorry.
Right, it's from the Gion.
also, count 4 is a PBL, Your Honor.
It is.
So based on that, it would be objected to in the court at this time.
All right, Mr. Lejean, it appears that count 4 in 2022 CF 3037 is a crime punishable by life. Judge Tennis has issued no bond. The court's going to continue that finding of no bond.
Speak on the bond issue for just a moment.
Sure.
He has no prior felony record. He is scheduled to have a catheter put in November the 10th due to his heart situation. They brought him to the hospital yesterday before they brought him to the jail. At this point, he still hasn't received any of his heart medication. They did give him some blood pressure medication, but they haven't given him his heart medication because they haven't gone through the system to get it to him yet. And of course, they won't, his family brought it in, but they're not going to let any of that go in because you never know if it's the real stuff. He's in the medical ward, and I would just note that he sort of needs to get that catheter put in, whether he's here or not here.
Understood, Mr. Lejean. A reasonable request. Case law indicates that the IA judge is not required to conduct an Arthur hearing, and the state is requesting an Arthur hearing in this case. What I will do for you is I will hand walk these documents down to Judge Young, personally let Judge Young know of your client's medical issues and ask them to expedite a request for bond if that is filed by the defense.
Thank you, Your Honor.
Yes, sir, Mr. Lejean. All right, Mr. Witters, you're going to remain on no bond on your 2 cases, and I'm sure Mr. Lejean, who's a very experienced trial attorney, will get you in front of Judge Young as soon as possible to address those considerations for bond. Thank you, sir.
Do you want no contact?
Yes, please.
Okay.
All right. State of Florida versus Joshua Williams. Good afternoon, Mr. Williams. Mr. Williams, you're with us based on a warrant. It's out of Orange County. Warrant does grant you bonds in the following amounts. As to the allegation of grand theft auto, your bond is set in the amount of $5,000. As to the allegation of possession of methamphetamine, your bond is set in the amount of $2,000. As to the allegation of possession of drug paraphernalia, your bond is set in the amount of $1,000. And I believe that is the only warrant that's holding you. I will appoint the Office of the Public Defender if they are not representing you at this time. Actually, do you need a representation if it's within our own circuit, or would you prefer that that be handled over in Orange County? You want me to appoint the Office of the Public Defender or no?
Yes, I actually already have a public defender.
You already have one over in Orange County? All right. All right, thank you. State of Florida versus Elliot Castillos. Thanks. Good afternoon, Mr. Castillos.
Good afternoon.
Mr. Castillos, you were arrested based on an allegation that you failed to appear for pretrial. The underlying case is 2022 CF 525. That's the possession of methamphetamine, possession of drug paraphernalia case. Based on your failure to appear and Judge Young finding that to be willful, he issued no bond. You're going to stay on no bond until we can get you in front of him to explain what's going on, and I will appoint the Office of the Public Defender if they were not previously appointed. Thank you.
Pre-trial December 7th, 9 a.m., courtroom 5F. Jury trial January 3rd, 9 a.m., courtroom 5F.
State of Florida versus Richard Gordon. Good afternoon, Mr. Gordon. Mr. Gordon, you are here with us based on an allegation that you violated your probation. The allegations in the affidavit from your probation officer indicated a violation of Condition 5, which is a new law offense alleged to have occurred on September 20th, 2022 down in Dade County. Looks like that is the sole allegation of violation of probation. Based on that information, Judge Young issued a warrant, and that warrant has no bond based on your designation as a violent felony offender of special concern. You're going to remain on no bond, and I will appoint the Office of the Public Defender to represent your interests. Thanks.
Leopia Raymond, November 14th, 8:45 a.m., courtroom 5F.
Hold on just a sec. I can't hear you.
Judge, he's saying he's got a private attorney.
Okay. All right. I'll withdraw the appointment of the Public Defender's Office. We don't have a notice of appearance.
On the case, it states Michael Morrison was, but it was deactivated October 6th.
Okay.
Of this year. I'm sorry. Someone set him on the case, but then they deactivated as well.
Okay.
So,
Mr. Morrison was on the case. I'm not sure that he still is.
give me a moment, I can see it.
Sure. I want to make sure that this gentleman has representation if he qualifies.
Client believes he's still on the case, Your Honor.
Okay. All right. Have Mr. Morrison file his notice of appearance with us, and he'll be notified as to the pending warrant and bond conditions. State of Florida versus Javante Holden. Good afternoon, sir. Sir, you are here based on a warrant in 2022 CF 2224. That warrant was signed by Judge Sandor, finding probable cause for the allegation of grand theft auto. Judge Sandor has set a bond in the amount of $5,000, and I will appoint the Office of the Public Defender to represent your interest. Thanks. State of Florida versus Kevin Jones.
Your Honor, he's detoxing. I'd ask for a reset.
Thanks. We'll call Mr. Jones's case tomorrow. State of Florida versus Ryan Monroe. Good afternoon, Mr. Monroe. Mr. Monroe, you were arrested on 2022 CT 204. That was an allegation of failing to appear for arraignment on a no valid driver's license charge. Judge Epperson issued a warrant, but he did set a bond in the amount of $500. Looks like at the point when law enforcement was executing that warrant, it is alleged you pick up a new law offense in 2022 CF 3134. Those allegations are possession of a weapon or ammunition by a convicted felon and trafficking in fentanyl, 4 grams or more. I've read the charging affidavit. I do find probable cause for that allegation. Bond in count 1 is going to be set in the amount of $4,000. Bond in count 2 is going to be set, this was over 14 grams, in the amount of $250,000. And I will appoint the Office of the Public Defender to represent your interest. Thank you. State of Florida versus Michael Walker.
Judge, for that last case, did you say 14 or 4 grams?
The charging affidavit indicates clear baggie with 14.7 grams of a clear crystal-like substance, which was tested.
Yeah, we're showing 4 grams here. I don't have the arrest report in front of me.
Yeah, it says 4 grams or more.
Okay.
So I don't know what the state's going to end up doing with it. It is charged, at least on the charging affidavit, as trafficking in fentanyl 4 grams or more, but.
Okay, thank you, Your Honor.
Yes, sir. Michael Walker. Mr. Walker, good afternoon. Mr. Walker, you got two issues with us. One's in 2022 CF 3077. That was an warrant arrest. The allegation was cocaine with intent to sell or deliver within 1,000 feet of a specified area. Judge issued a bond in that case and set the bond in the amount of $10,000. You also have 2022 CF 3136. That is a new law offense alleging possession of cocaine and possession of drug paraphernalia and possession of a weapon or ammunition by a convicted felon, that weapon being a firearm. Court finds probable cause for the new allegations. Bond in count 1 is going to be set in the amount of $1,000. Bond in count 2 is going to be set in the amount of $500. Bond in count 3 is going to be set in the amount of $4,000. I'll appoint the Office of the Public Defender on both of your cases. Thanks. State of Florida versus Sean McCray. Good afternoon, Mr. McCray. You have also two cases with us. The first is 2022 CF 3132. That is an allegation of possession of controlled substance, possession of drug paraphernalia, and resisting an officer without violence. I have reviewed the charging affidavit. I do find probable cause for counts 1 and 2. Bond in count 1 is going to be set in the amount of $1,000. Bond in count 2 is going to be set in the amount of $500. Well, I think there's a suspicion that you resisted the lawful commands. I can't find probable cause based on the information in the affidavit. So I'm going to release you on your own recognizance as to count 3 only. State may end up filing charges on that. They may not, but you've got a bond on the first 2 counts, and you're released on your own recognizance as to count 3. You also have 2022 CF 3133. That was an allegation of introduction of contraband into the jail and possession of marijuana less than 20 grams. I do find probable cause for those allegations. Bond in count 1 set in the amount of $2,500. Bond in count 2 set in the amount of $500. And the Office of the Public Defender is appointed on both cases. Thanks. State of Florida versus Kenneth Parker. Good afternoon, Mr. Parker. Mr. Parker, you were arrested based on allegations of possessing a controlled substance, possessing drug paraphernalia, and resisting an officer without violence. Unlike Mr. McCray, the court does find probable cause for all 3 counts. I will set bond in all 3 counts. Bond in count 1 is going to be set in the amount of $1,000. Bond in count 2 set in the amount of $500. Bond in count 3 is set in the amount of $500 for a total bond amount of $2,000, and I'll appoint the Office of the Public Defender to represent your interests. Thanks. State of Florida versus Timothy Weiser, 2022 CF 3137. Good afternoon, Mr. Weiser. Mr. Weiser, you were arrested based on an allegation of possession of methamphetamine and possession of drug paraphernalia. I read the charging affidavit and do find probable cause for your arrest. Bond in count 1 is going to be set in the amount of $1,000. Bond in count 2 is set in the amount of $500, and I will appoint the Office of the Public Defender to represent your interest. Thanks. State of Florida versus Elijah Canala, 2022 MM 2422.
Judge, Mr. Weiser is saying that PTR came over and talked to him. Does he have PTR, or are you just giving him a straight bond?
He qualifies for pretrial release plus a bond. We have a witness present, and I was going to consider issues of bond. I'm sorry. That was Mr. Canella. Mr. Weiser does not qualify for pretrial release. He's got some kind of other legal constraint. Sorry. State of Florida versus Elijah Canella. Mr. Canella, good afternoon.
Good afternoon.
Mr. Canella, I took a look at the charging affidavit. You are here based on an allegation of battery, domestic violence related. Based on the affidavit, I do find probable cause for the arrest that has already occurred. I will appoint the Office of the Public Defender to represent your interests. We do have a witness present. Good afternoon. Ma'am, we're going to place you under oath. If you please raise your right hand for us.
Do you solemnly swear or affirm that the testimony you're about to enter into this case to be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Do you need the,
Yes.
okay. Do you need the assistance of an interpreter, or are you good in English?
No, I'm good.
Good in English, just a little nervous?
Yeah.
Okay. So what's going to happen is I'm going to ask you some questions about your thoughts as to whether you wish to have contact with Elijah, and if you guys live in the same residence, whether you wish for him to return home. I see that you were staying in a motel. Are you still in that motel?
No, we're supposed to go back home to Washington in 2 weeks.
Okay, so you're here on vacation? All right, thank you. Did you fly here or did you drive here?
We flew here.
Flew here, okay. And where are you going to be staying for the next couple of weeks? Do you know?
I'm not sure right now.
Not sure?
Probably another hotel.
Okay. All right, you are, why don't you give me your name just for the record, please?
Isabel Bobin.
All right, thank you. You are listed on my charging affidavit here as the alleged victim in this case. I'm going to ask you some questions in making some decisions about contact and where Elijah will be allowed to be while the case is pending. Have there been any instances of domestic violence in the past?
No.
Okay. Do you have a means of communication, such as a cell phone or a phone that you could call law enforcement if you believe that you were in danger of domestic violence?
Yes.
Okay. Do you have any fear of having contact with Mr. Canella?
No.
Okay. And do you wish to reside while you're here and back home in the same residence as Mr. Canella?
Yes.
All right, thank you. Are there any minor children between you and Mr. Canella? No, okay. Thank you. Mr. Rosa, do you have any questions of our witness? If you're speaking and the microphone's on mute.
Didn't realize, I'm sorry. So I have one question, Your Honor.
Go ahead.
I just want to ask, would you be comfortable calling law enforcement if there was any further issues between you and Mr. Canella?
Yes.
Her response was yes.
No further questions, Your Honor.
Thank you. Ms. Boudin, any questions?
No questions from the state, Your Honor, just argument.
All right, thank you. State's position?
Yes, Your Honor. State would be asking for there to be no contact at this time, Your Honor, between victim and defendant, based on how recent the events are. It also appears from the report that Ms. Bobin initially told officers that nothing happened, but when she was taken aside by Deputy Daniels, she came forward and said the defendant did slap her, and then the deputy did witness a bruise under her eye. Towards the end of the report, the deputy also advised that she told the deputy that Mr. Canella has been aggressive to her in the past. So based on these statements in the report, Your Honor, based on the officer observing an injury and anonymous witnesses calling law enforcement, also the defendant and the victim is from out of state, so the state has not had the opportunity to review history. State would be asking for no contact at this time.
Thank you. Ms. Bobin, the state of Florida is requesting that you and Mr. Canella have no contact. That would be the most protection that the court was allowed to order at this stage in the proceeding. You have indicated that you wish to have contact with Mr. Canella. Do you understand that's a lesser protection than the court is legally able to impose? Do you understand that? Okay. And with that understanding, is it still your request to have contact with Mr. Cannell?
Yes.
Okay. Court is going to find that you are in the best possible position to weigh whether you are in fear of Mr. Cannella or not. The court is going to allow contact. Mr. Cannella, that contact, however, is going to be non-hostile contact. Let me explain exactly what that means. It means exactly what it sounds like. You're not to put your hands on.
I understand, Your Honor.
Yes, sir. You're not to put your hands on Ms. Boban without her permission. No loud verbal arguments, no swearing, no getting in each other's faces, no threats in person or through text message or social media. Do you understand?
Yes, Your Honor.
All right. Court is going to allow you to cohabitate as you choose, where you choose, and should there be any additional issues, the court would consider that to be a violation of the conditions of your bond, Mr. Cannella, and it would be likely that you would wind right back up in jail. Court is going to set a bond in this case in the amount of $500 plus pretrial release conditions, those conditions as previously announced, being no hostile contact. And I will appoint the Office of the Public Defender to represent your interests. Thank you. State of Florida versus William Green. Good afternoon, Mr. Green.
Yes, sir.
Mr. Green, you are here with us based on an allegation of failing to leave property after warning or trespass. I read the charging affidavit and find that there is probable cause for your arrest that has already occurred. I know that you told law enforcement you have a defense to that allegation, but that will be a discussion for another day. I will set bond in your case. Your bond is set in the amount of $250 with the special condition of bond that you not return to 504 West Vine Street.
Your Honor, well, him, he was found incompetent on case 21 CT 641 531 2022, and we were going to see can we get him ROR'd on this.
Is he on conditional release?
When I did look, it just said for him to not return.
Where?
Or not to commit any more crimes. And that's the only thing that I see. 21 CT 641 or 0641. And also on that same case, he was like failed to appear on 3 times for that same case.
Yeah, I don't think releasing him on his own recognizance is appropriate. It sounds like he may be in violation of his conditional release, and there's some history of non-appearance. So the court is going to set that bond amount in the amount of $250 with the bond condition that he not return to the 504 West Vine Street. I will appoint the Office of the Public Defender to represent his interest. Mr. Rose, if there's competency concerns, you certainly know how to get that paperwork in front of the county court.
If I may, he has a competency status hearing on December 2nd.
Okay. He's already got a court date on December 2nd in front of Judge Epperson. Thank you. So Rosa, that was the last of the paperwork that I have. Do you have any clients that have yet to be addressed?
Your Honor, did you call Jesse Madden? I can't remember.
He bonded out.
I believe he bonded.
Oh, got it. Thank you, Your Honor.
Have a good afternoon. Thanks for your help.
Thank you.
We'll be in recess.